prosecution had done a series of things that were improper, but nothing on this one. There was a document the prosecutor was told not to show the jury, and she went and displayed it to them, and there was evidence she was not supposed to argue, and she argued it immediately on opening. So we filed some mistrial motions to document the situation, but we were getting the idea that we were getting a pretty fair trial, that things were going well, and all of a sudden, I had leaned over the attorney next to me and said, they haven't pulled a dirty trick yet today. Maybe they're relaxing. Maybe they're just going to do the case. And all of a sudden, the prosecutor asks the witness to step out of the courtroom, asks to approach, and pulls out this email, which he had no business having, and said, we have to discuss this, and the courtroom erupts. Comes back in and says, this has sensitive information on the jury. Somebody sent it to us. Wouldn't say who had sent it to them. He said somebody who shouldn't have been on the list. There was nobody who shouldn't have been on this list. And it was me, the paralegals for the case, and the defendants, and we CC the other lawyers.
Well, it sounds like somebody did get on it, or somebody did it.
When we checked, the court asked Mr. Irwin, who was one of the defendants, who was the administrator for the list, to go on there and pull up the names. And by the way, there was a detective who never identified what agency he was with, who was working with them, who was not wearing a uniform I've ever seen before, who knew how many people were on that list and who was on it. And all of that is confidential. And it's supposed to be very, very secure. There's multiple levels of encryption to keep anybody from getting information. First name that comes up on the list is someone named edmund.bob@gmail.com. No such person had subscribed. Mr. Irwin needed to approve anybody getting on that list. He hadn't. This guy had gotten himself on the list. And we still don't know how that happened. And there's this email. And we don't know how long this was going on, because they picked a communication from last weekend that could not have been retrieved through the archives. The archives are very sealed. And picked the one that they could say, look, this was communicated, rather than, we don't know how many months of strategy for trial and discussions about what motions we were going to file. And so we don't know how long this was going on.
Obviously, you wanted to keep this list confidential, because of your own case and your own strategy that you guys have been talking about. What about the privacy of the jurors? What is the privacy of the jurors' information?
Well, we don't have the names are on there, and there was some other descriptive information that we are allowed to have that information, and the defendants are allowed to have that information. And as I read the rules, and I've looked at them very closely, the legal team on the case is allowed to have that information. We all do jury selection as a group. I mean, we went into trial with 17 people plus the team, and to have decent jury selection, it goes quickly. We all have to share this kind of information and be strategic about what we want to do so we get a proper jury. We sure don't want, so we take great safeguards. In addition, the rules require that we do that. And I'm very, very concerned about making sure that I don't do anything that compromises anybody's safety.
But at the same time, somebody it sounds like got on that list.
And we really want to know who. And it's not the kind of knowledge that members of the public generally have. I mean, RiseUp.net is designed to be extremely secure. It's a place that we strongly believed, and accurately so until now, that we could have confidential communications. Otherwise, we wouldn't do it that way. And it's not just the juror information. I mean, we're very concerned about that. We don't know what else they knew about our trial strategy, our internal arguments about how to proceed, what motions we were going to file, what those motions were going to look like. I mean, it goes to the heart of attorney-client privilege. The Sixth Amendment says that defendants have an absolute right to counsel in trial, and that right is absolutely secure, so that they can have a proper defense. And we don't know when that got compromised.
When you look out there, apparently the reporter who worked for the Olympian wrote the article said he was able to, with some basic information, he was able to get on the list.
Yet somebody changed the settings. When Mr. Irwin got on last night, the settings had been changed for what they were previously, and all of a sudden the system was publicly accessible. It had not been, and they're in the process of checking with RiseUp to find out when those settings were changed, if there's a log of that. But they were not changed at the time the email was sent out. We think we've been hacked. We think we were hacked by somebody with some agency of the government. We don't know who this detective was. There's nobody with a private interest in hacking onto a defense listserv. The only people with an interest in doing this are the prosecutor's office, and I have no reason to suspect that they themselves did this, or some law enforcement agency. Nobody would have an interest. It strikes me as going back to the kind of stuff that the Nixon administration did, where they would place informants in the defense camps. I was talking to my attorney last night, Len Weinglass in New York, and he reminded me that there were Black Panther cases in California where the federal government had planted informants who volunteered to help out with the legal team and had worked their way into the staff and provided that information to the prosecutors, to the government. So it sounds something like that.
Let me go back to the trial. There's now been a mistrial declared. You thought you had, victory within your grasp. What do you hope happens now?
Well, as far as the case goes, we are entitled to a dismissal. We should get a dismissal. If they are going to try and bring this case again, we're going to try and exclude the prosecutor's office based on this previous conduct. In the meantime, we've been invited to. They refused to tell us who this guy was. They refused to tell us where the information came from. So we are going to, before we file a dismissal, we're going to file a motion with the court by the end of next week, demanding that the prosecutor show cause why they should not have to give us this information, so that we can know what's really going on. And they were very, very unwilling to give us that information. We're also trying to track it ourselves if we can.
Okay.